Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Hello and welcome to the podcast. Glad everybody could tune in. Today we're going to be discussing when marriage and death collide, a discussion of certain crossover issues of probate law, which is the area I practice in, and family law, which is an area I don't practice in. And nobody likes divorce, and not too many people that I know of anyway. And clients do call up with dissolution issues. Sometimes these things happen later in life. And when they do, it's very typical for me to refer them to my friend and colleague, James A. Jackson, Esquire, who is our guest today. Jim is a very experienced family law attorney practicing in the Coachella Valley of Southern California for well over 30 years. He is an AV-rated attorney with Martindale-Hubbell. He is a go-to person for many people that I know amongst my colleagues practicing in Southern California. And he's extremely experienced in family law matters and has actually been a judge pro tem for periods of time, been the president of the Desert Bar Association Family Law Bar, is an all-around good guy and a very knowledgeable about the areas of family law. And just as our usual disclaimer, the podcast people need me to tell you this, and I need to say it for myself, that nothing in this podcast is intended to provide or will provide legal advice. Viewers with legal questions should contact their own attorney for legal advice. If you have a dissolution matter, you may want to contact Jim. If you have a probate matter of any kind, you can feel free to call Bochnewich Law Offices, APC, and we'll be happy to try to help you. As an intro, the title of our discussion is When Marriage and Death Collide, a discussion of certain crossover issues of probate law and family law, which would suggest that the initiation of a dissolution of marriage may be the only genesis of crossover issues between the probate code and family law. There are plenty of places where probate code and family code might intersect. One that comes up from time to time is in the conservatorship practice, when you have a person who's been ruled to be in a conservatorship, that whether or not they would still have the right to marry. So there's these issues all across the board between family law and the probate code. However, the number one question that typically comes up does relate to dissolution actions when we're talking about estate planning and what to do with your assets when you're about to go through a divorce. What can a person do and when a divorce action has been filed, and what can a person not do? And we turn our attention to a term that practitioners in the family law field know about. It's called ATROS, automatic temporary restraining orders. So I'm going to ask Jim, let's dive right into it. Jim, what is meant by ATROS?
Well, as you indicate, Peter, ATRO is a mnemonic for automatic temporary restraining order. And when a party files a divorce, that activates these restraining orders and restricts parties from unilaterally self-dealing with assets, which would be inclusive of bank accounts, other financial investment accounts, IRAs, pensions, KIOs, real property, and personal property as well.
All right. So when we're talking about a restraining order, it's important to know when the restraints kick in. It's an automatic restraining order. It's on the summons, of the family law summons. It's written on the back of the family law summons. So Jim, when do these automatic restraining orders kick in for petitioner and respondent?
Pursuant to Family Code Section 233, subsection A, it activates for the petitioning party the minute that they file the dissolution action. With regards the recipient or respondent party, it activates once they have been served. Due process rights have to be protected for the receiving party. They arguably cannot be charged with the responsibility to be in compliance with these restraining orders when they have not been noticed that the orders actually exist.
Good point. Let's unpack that a little bit. So if you're bringing the action, if you're the party petitioner bringing the dissolution action, the minute you file that, you're bound by the automatic temporary restraining orders because you're bringing the action. You know what you're doing. You're bringing the action. You've got to live by the same restraint you're going to effectively, I suppose, impose upon your spouse.
That's correct. And in fact, you need to be responsible, whether you have an attorney or not, to be charged with having read that, having understood it, because it's statutory. So if you didn't have an attorney and you didn't read it, and that was going to be your explanation or excuse for why you violated these restrictive terms, that would not be an appropriate or a legitimate excuse as far as the court was concerned.
You made a good point about the receiving party not being obligated to respond or adhere to the restraining orders until they're actually served. But as soon as they're served, ignorance of the law is no excuse. They've got to read what they're served with, and it's plain, pretty bold-faced type on the back of the summons, certain things that you can't do. And the receiving party is responsible for that. I have a question at this juncture for you.
Sure.
First, has it ever happened where someone is filing for a petition for dissolution and maybe they realize that there's ATROS or not, but just prior to doing it, I hope this isn't too novel of a question, but just prior to doing it, they may have moved the assets and then they file. Would that, in most cases, be considered still a violation of ATROS? Would it relate back a little bit, or how does that work in your experience?
It would not. Until the ATROs go in effect, you can't be charged with having violated the ATRO because there's no restrictive restraining order in place. However, if you have made significant actions relative to assets at any time in close proximity to the filing of a divorce, and or you have moved significant assets, transferred assets, at any time without the knowledge, permission, or consent of your spouse, in some time that's proximally close to the filing of a divorce, you could be looking at a Family Code Section 1101 violation, which is a breach of fiduciary responsibilities to the community. Both parties owe a fiduciary responsibility to the other when it comes to all financial matters. The closer the transaction was to the time of the filing of the divorce, the more likely the court would be to look at it as having been taking advantage and having been inappropriate. You could end up being on the receiving end of Family Code Section 271 sanctions and attorney's fees. And depending upon the significance of the negative conduct, the court does have discretion to award community assets to one party and not divide them, as you might pursuant to California community property law, based upon the intentional actions to try to take advantage of their spouse.
So there are serious ramifications for playing fast and loose with the rules, and best not to do that. Best to consult an attorney and not try to pull any tricks on your spouse, whether you're the petitioning spouse or on the receiving end. And with that, I'll say, what if an unexpected spouse could happen. They get hit with some papers, or maybe they're expecting whatever it is. They're immediately charged. They can't just run out and start moving money around. That ATROS, as soon as they get that paper in their hand, they're bound by the same restraining orders.
It's assumed by operation of law that they have read it and understand it.
Okay.
And they are bound and obligated to it.
All right. So I'm looking at the ATROS right now, and there's a couple of them that don't pertain particularly to what we're talking about today, but I'll go through them very quickly just to give the sense of the gravity of how serious they are. I mean, the first one is that you're restrained against removing minor children of the parties from the state or applying for a replacement passport for those minor children without the prior written consent of the other party or an order from the court. You can't do anything with the kids. That's moving them away from the other spouse. And the next one is there's a restraint against cashing, borrowing, canceling, transferring, disposing of the beneficiaries of any insurance, including life, health, automobile, disability, for the benefit of the parties and the minor children. Can't do that.
Let me break in for just a second, Peter. With regards to the first one, where you spoke of the restraining order against moving children out of state, generally that is done at the initiation of a divorce to make sure that a party doesn't leave the state and the jurisdiction of the court. But I would tell you, when parties have minor children, that's an issue that is addressed very quickly in terms of what issues are in the divorce. Custody, visitation, and support issues are some of the first issues that we encounter in the progression of proceedings in a divorce. And generally, the court will end up allowing for travel out of state so long as it's for short visits, vacations, but not with intention to permanently relocate. And then with regards the indication you made of the other restraining order as to not encumbering assets, not changing health insurance beneficiaries, I think it's important to note that the types of penalties that could occur for somebody could be very, very significant. A good example is where a party decides he doesn't want to pay for health insurance for wife and cancels health insurance. Now, if health insurance was in place at the time that the party separated, he is obligated by law to maintain that insurance until the divorce finalizes. What kind of situation could he be looking at? Let's say that the worst happened and wife ended up going through some catastrophic situation with just huge medical bills and no insurance coverage because husband had canceled the policy in violation of ATROS. Guess who the court is going to award all of those medical bills to as debt? They're going to give it to the spouse that canceled that health insurance. And I mean, that could drive you into bankruptcy. It could be that significant.
And where we would see much of this with an older clientele is if someone's facing has significant health concerns. Maybe they're not on Medicare yet, or maybe they are. I mean, I guess that the restraint against canceling insurance would apply to everything, supplemental insurance, all of that. It's all off limits until you get an order from the court or consent or work something out amongst counsel.
That is absolutely correct.
Okay. Number 3 of the restraining orders that's both provided by statute, as you mentioned, and is also right on the reverse of the summons, the standard, the FL 110 summons for family law dissolution actions, states you're restrained from transferring, encumbering, hypothecating, concealing, or in any way disposing of any property, real or personal, whether community, quasi-community property, or separate, without the written consent of the other party or an order of the court except in the usual course of business or for the necessities of life. What is meant by that?
Well, this is intended, once again, to prevent anybody from self-dealing with assets. And this is even inclusive of separate property assets. And I know a lot of parties going through the divorce process would be concerned as to why it is they can't even utilize or access their own separate property assets that maybe they had prior to marriage or received from inheritance. And the reason for the restriction with the restraining order, even as to separate property assets, is because the court has not made a characterization yet. And until it does, every asset is subject to all arguments, with decisions to be made on the merits of whatever information is provided by both parties as to each asset. So they cannot, without violating ATROS, utilize their own separate property assets, with the exception of taking care of the necessities of life. And one other exception of note, which is you're able to use community property or assets to pay your attorney's fees.
Right. So to get you through the process that's been initiated. So
Yes.
as an example, if someone, a party to a dissolution action, has a separate property asset that they inherited from their grandmother, and they've had it for years, it sits in an account and has the community is not doing anything at all to enhance it. It's just generating interest, and the person who inherited it might receive that interest, take it whenever they want, or have access to that money. So I think it would be probably characterized as an inherited asset without the involvement of the community. There would be, am I fair to say, a presumption that it is separate property. Even then, you can't touch it.
That's correct. Not until the court has characterized the asset. A lot of people want to claim that something is their separate property. And until the court has heard all of the arguments and evidence and made a decision, or if the parties are able to enter into a stipulated agreement and file that with the court, that also becomes an order. But it would take such an agreement or an order before the person would be out from under the weight of the ATROS.
Number 4 ATROS is a restraint against creating a non-probate transfer. And this one gets to the heart of what we're talking about on the crossover issue. It says, you are restrained from creating a non-probate transfer or modifying a non-probate transfer in a manner that affects the disposition of property subject to the transfer without the written consent of the other party or an order of the court. Before revocation of a non-probate transfer can take effect or a right of survivorship to property can be eliminated, notice of the change must be filed and served on the other party. So a non-probate transfer would be a pay on death account, a transfer on death account for stock holdings, things of that nature. It could be am I correct? Or if you have a joint tenancy with right of survivorship, you can't just go ahead and terminate that and create a tenancy in common yet. Is that a fair statement?
That is a fair statement. Oftentimes we get into a situation, especially with elderly parties who are going through the divorce process, where a couple of different situations have a tendency to arise. One is to have a property in joint title, joint tenancy, and joint tenancy has right of survivorship. Now, when parties are married, they're happy. A right of survivorship is probably a good thing and a desirable thing, because you want to be able to leave that asset to your loved one, your spouse. But when you're going through divorce and the love is gone, then that changes things markedly. And rather than having a right of survivorship, you may wish to protect your heirs on your side of the family, your children or whoever. And to be able to do that, there would need to be a transfer deed from a joint tenancy to a tenancy in common, which would then allow each respective side to have their interests devolved down to their heirs. And the way that this would be accommodated, you would need to file a notice of intention with the court to revoke these non-probate transfers. And that does give the other side a right to object and an opportunity to be heard, but highly likely that the court would agree that, especially with elderly parties, that it would make sense to revoke these transfers, because there is a significant possibility when parties are elderly, one may decease before the divorce finalizes. In California, when somebody dies and the divorce has not been finalized, the divorce action is dead. And therefore, everything will be subject to however things were titled: bank accounts, trust, all financial assets. So in those situations, it oftentimes makes a lot of sense to go in and revoke those non-probate transfers.
In my own personal experience, I have a case right now where there was an argument that someone had filed a divorce. They didn't actually go through with the divorce, but the family on the other side of the deceased husband, was arguing that, look, they were going through a divorce. She shouldn't be getting all of this, whatever. I said, they didn't go through with the divorce. It was filed in a peak of disquietude in the marriage at that time. They didn't pursue it. She didn't pursue it. He didn't pursue it. He had a will that left her everything. She took care of him up to the date that he passed away. And basically the court saw it our way, that the will was completely valid, and she was named executor of the will. Where there's an executor involved, where it's specifically named, sometimes the filing of a divorce can change the priority of how you would serve in an intestate estate, but that wasn't an issue in that case. So just touching upon what you said, if you don't finish it, it is the way it is. So if you don't undertake actions to undo the estate plans or the things that are in place or the non-probate transfers, and the divorce goes on for a while, they will be left exactly the way they are, the way you had them. That's a fair statement?
That is absolutely a fair statement.
What are some of the penalties that could be incurred? I think you touched on it a little bit, but we might want to elaborate on that a little bit more if someone is found to be in violation of these automatic temporary restraining orders. What could a judge order against a person?
Well, we have Family Code Section 271 sanctions, which is a penalty. It's punitive in nature for not having dealt in good faith and in a spirit of cooperation, relative to the law, relative to the other party's financial interest in the divorce. Depending upon the number of violations, and just how chronic or bad it has been, the court could find that this is a Family Code Section 1101 action, again, breaches of fiduciary responsibility. And one of the options that the court has would be to award an entire asset rather than dividing it pursuant to California community property law, because of the inappropriate and egregious acts of the spouse in attempting to gain financial advantage by being dishonest.
That's very interesting, because when people are at the point of dissolution and they're going at each other in a marriage that may have lasted many, many years, and you've got these gray divorces that we have now, where people are getting divorced maybe later in their life. The court expects you to deal with your spouse fairly. The court expects you by law to still observe all of those fiduciary obligations that you have. You say fiduciary obligations. Spouses have fiduciary duties to their spouse to deal fairly in the disposition, the dissolution, and the divvying up of their assets. And I guess the court can exercise its equitable powers to punish someone who is found to not behaving that way, which is counterintuitive to the way people want to go at each other in a divorce. And you have to do you have to explain that to people to calm them down sometimes, to put a leash on it so that they don't hurt themselves by being too aggressive?
I think it's real important that the attorneys explain the rights, duties, obligations, and responsibilities to their clients as to what's important in going through the process of divorce, in protecting them from themselves, if that's necessary. I always find it's important to educate my clients. I want them to, not just hear it, but understand it. So we explain it, we take the mystery out of it. So there's really no excuse or justification if they go out and violate. Clearly, if they were to do that after they have been forewarned and educated as to what their responsibilities are, then they have no one to blame but themselves for subjecting themselves to what could be very significant and substantial penalties.
Now, there are some things, according to California Family Code Section 2040, that you can do. And I'd like to just go over some of the things that's listed in the code that you can do. And that's at 2040B. And this section does not restrain any of the following. It doesn't restrain the creation, modification, or revocation of a will. So what is your understanding of that? It's spears expressly that you could do a will. Is it still best to get permission from the court in that circumstance, or in that circumstance you could do a will, but you just can't you can't change how does that just juxtapose with the other restraining orders that says you can't do anything?
A will is a vehicle for disposition upon death.
Sure.
As you're going through a divorce, nobody has died yet.
Right.
So you have an absolute right to change your will.
Great.
So that's not really a problem. What you need to be careful of in maybe creating or drafting a new will, you certainly wouldn't want to have provisions or dispositions over some property that may not have been adjudicated yet, and you don't know exactly how that property would be divided. So, it might be a little bit difficult to have a very term-specific will when there has yet to be judicial determinations and or stipulated agreements between the parties as to who is going to have what in the way of assets.
And if you did make a will that, all right, I'm going to unpack that one a little bit. If you did make a will that purported to will away from your spouse property that you thought was your separate property, but turned out not to be your separate property, maybe she had gained a community property interest in that property over time during the length of the marriage, would that be considered a violation of ATROS necessarily, or would that just be something where you just have to unwind that asset and the person would just be claiming a community property interest in that asset?
Yeah, it wouldn't be a violation of ATROS because it's not a transfer of any asset at that time because nobody has died. But I do believe it could become an issue in the probate matter after the death of the party if somebody arguably has good evidence to show that their community interest was in the will and that it should be invalidated because the decedent did not have the right to will away the other spouse's interest in property.
Yeah, right. That's where we would see it. Someone would say, this is my property. I've done it according to 2040B. I've modified my will and I've changed it. I had a right to do that, but the spouse comes in and said, you had a right to do that, but you didn't have a right to do that with my property, which yours is, and there would be the appropriate petition to get that back out of there. Now, Family Code 2040B2 says there is no restraint against the revocation of a non-probate transfer, including a revocable trust, pursuant to the instrument, provided that notice of the change is filed and served on the other party before the change takes effect. Is that something that you have to have an order on or permission, or you can just do that? How does that work in your
Well,
practice?
this is the situation where you need to file a notice of intention to revoke with the court. That way, the other side has been given their appropriate notice and due process rights. It must be addressed with the court before you would have the right to make any modifications.
Moving
But
on.
you do have the right to request it.
Okay. Best to always request, always give notice. We'll go on to number 3 here. It says this section does not restrain also the elimination, quote, the elimination of a right of survivorship to property, provided that notice of the change is filed and served on the other party before the change takes effect. So if you've got a house with joint tenancy and right of survivorship, and you say, I'm not going to do that, I'm going to terminate that. We're going to create a tenancy in common, which is we both have an undivided interest in the property, but if I pass away, I don't inherit your part. And if you pass away, there's no right of survivorship. But
That's
that has to
correct.
be done.
And the way to approach that, at least informally initially, would be to go to the opposing party and or through their counsel and attempt to get an agreement that could be delineated in a stipulation between the parties, signed and executed, filed with the court. That resolves the issue. It becomes an order. If you cannot get that agreement, then you would need to file the motion with the court seeking the court's permission to revoke the non-probate transfer.
What percentage of time would you say in your practice are you able to work out things in that kind of ordinary, I'm dealing with opposing counsel, we're going to have a stipulation, I don't know if you can give me a percentage. There's a, like, if you've got someone on this other side that's as knowledgeable as you are, it's like, look, we know what the answer is. We really have to get together on these things, and you could probably hammer out a deal during the pendency of the dissolution, if I'm stating that correctly. I mean, how often does that happen?
If I had to speculate, I would say it would probably be on about a 50-50 basis, where you could expect informal cooperation and bring it to an agreement that could be filed with the court that would resolve the issue. Every case is going to swing on its own set of circumstances, and every case is unique in some way with regards what the financial circumstances are. Sometimes you've got real significant issues of reimbursements where parties are not comfortable with dividing assets or protecting personal interest by revoking interest. That would be an argument for the court. So it's just hard to say. You take it on a case-by-case basis. I would certainly always attempt the informal approach first before having to go through the cost and expense of filing a motion with the court on an adversarial basis to try to make that happen.
Is there a process where you're required to meet and confer with the other side before you do such a thing? Or I know in civil practice, if you're going to file certain motions, obviously, you've got to meet and confer before you do it. I don't know if there's a process in the family law practice where before you do any of those things, you should meet and confer.
You absolutely should. Most attorneys will put out a letter delineating for opposing counsel and their client what the request is and why the request is being made. And then you give a certain amount of time for a response. They will either agree or reject your request or not respond. And obviously with the last two, you would end up filing the motion of the court to take care of it that way.
Jim, in your experience as a family law practitioner, is the issue of estate planning trusts, the existence of trust, is that, what percentage of cases does that emerge as a significant issue in your practice of how to deal with those pre-existing estate plans and so forth?
Where we see it more often as a problem or an issue is with elderly parties that are going through divorce. Oftentimes they will have a living trust, or they will have jointly titled property. Those are probably the instances that will predominantly lead you to wanting to revoke the transfers. We see those more often than we do the others, although certainly where you've got accounts with a named beneficiary, that's another one that will also come up. But the other two are the ones I probably run into the most.
And when you're talking about elderly people going through divorce, I've been around long enough to recall or at least perceive that people would usually get to a certain point and maybe not contemplate a divorce if they were elderly, but we're seeing more of what we call gray divorces these days. Have you seen an uptick in that in communities?
Yes and no. Oftentimes, parties, rather than going through a divorce, will opt for a legal separation, where if they do that, they're able to continue to be provided health insurance, because in a divorce action, when a divorce finalizes, a spouse can't continue to carry the other party on health insurance even if they wanted to. But in a separation, they could. So oftentimes there may be serious health considerations, and the parties are amenable to going through a legal separation rather than a divorce, where, essentially you can do all the things in a legal separation that you can with a divorce. You just don't get the final status of being divorced. And of course, when you got a legal separation and not a divorce, it does not end up invalidating will provisions because you never got the divorce.
Whereas, so in that situation, as part of the legal separation, you would want to have the married couple review everything, really go over their estate plan. Maybe they would decide, look, we're just going to be legally separate. We're going to leave everything the same the way we did when we were married. They might do that.
Absolutely. And it's generally a good idea for family law practitioners to recommend that their clients seek out consultation with estate planning, wills and trust attorneys to go over these issues. Family law attorneys are not experts in that field. We defer to attorneys like yourself to be able to handle those issues for the parties. And then it generally works back with the family law attorneys, and whatever changes need to be effected, we see to it that they're made.
We appreciate that. Well, this has been an interesting discussion. I think we've just scratched the surface of where there's intersection between probate law and family law concerns. You've got an encyclopedic knowledge of the code, and you're able, from years of experience, and you're able to recite those things, and that's very comforting. And that's why you're a source of many referrals from us. And I appreciate your time, and I appreciate your being here on Your Inheritance. And I hope you have a happy holidays, and we'll see you again soon. And thank everybody for joining the podcast.
Thank you so much. It's been a pleasure, and I appreciate the opportunity.
You've been tuning in to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. If you're being sued over an estate, or if you feel you're not getting your share, Peter's firm can help you. You can find the show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.